Great. Hello, everyone. Thank you so much for joining us today and happy Pink Shirt Day. My name is Sadie and I'm the Communications and Fundraising Manager at Hub Cycling. And we're so excited to have this opportunity to share the work of one of our organization members and longtime supporters, RBS, Richards Buell Sutton, and to highlight one of the amazing lawyers, Michelle Quinn, who is a partner at RBS and co-chair of the Employment and Human Rights Group. So today we've got a anti-bullying and anti-harassment webinar for you folks, and I'll pass it over to Michelle.
Well, thanks very much, Sadie, for that lovely introduction. Hello to everyone who has signed up to today's webinar. Happy Pink Shirt Day to everyone. I'm here wearing my own pink t-shirt. I'm hoping for this to be, as Sadie and I were talking before this webinar began, a lunch and learn. So again, happy Pink Shirt Day. Welcome Hub members and friends who've signed up today to learn more about bullying and harassment in the workplace. Hoping to maybe talk for about 40 minutes or 45 minutes, and then to allow time for anyone who wants to ask me a question. There's no such thing as a stupid question, so please just ask away. All questions welcome. So let's get going, because I know it's on your lunch break. So workplace bullying and harassment, what you need to know. I've tried my best to give a broad overview about this topic. There's quite a lot in it, but I've condensed my slides to about 20. So I'm hoping to just tick off all the high level points. And even if we run out of time at the end, my contact information will be on the very last slide. So you can email me or give me a call, because I'm quite happy to continue having this conversation and to answer any questions that you may have on either bullying, harassment, or policies or procedures, and anything that you're uncertain of. Okay. So what am I covering today in this webinar? Well, it's divided here into 4 parts. And I should have said at the outset that my PowerPoint slides are available. So please feel free to reach out to Sadie or anyone here at RBS if you would like a copy of the slides. So the webinar is divided into 4 parts. What constitutes bullying and harassment? So we're going to be learning today what is bullying and harassment and what is not bullying and harassment. We're also going to be learning about the key legislative framework in place. So we're going to be talking about the BC Human Rights Code, and we're going to be talking about the Workers' Compensation Act, WorkSafe BC policies. So you will hear me talk about WorkSafe BC's policies. You will hear me talk about the BC Human Rights Code that prohibits discrimination in the workplace. Okay. The second part is going to cover, well, what are employers' obligations under the law? What obligations does an employer have? Are you aware of these obligations? And the third part will cover the importance of conducting an investigation. Why do an investigation when a bullying and harassment complaint has been filed? Why do that? Is it important? Do I need to do an investigation? What happens if I don't do an investigation? And then, as I said, at the end, I would really love to have a question and answer session to answer any questions, like I said, that you may have. Okay, so let's get into it. Part 1, what is bullying and harassment? I'm asked this all the time. So here we go. In BC, there are laws in place to protect workers from bullying and harassment in the workplace. So we're going to pay attention for the first 5 or 10 minutes to WorkSafe BC's policies, and then in part 2, I'm going to move into the BC Human Rights Code. So WorkSafe BC defines bullying and harassment as follows. Now it's a bit of a mouthful. Any inappropriate conduct or comment by a person towards a worker that the person knew or reasonably ought to have known would cause that worker to be humiliated or intimidated. So the key parts to this definition: really entails the humiliation component and the intimidation component, and that the worker knew or reasonably ought to have known would cause that worker to feel humiliated or intimidated. Okay, so just let that sit in for a second. Now we need to say, well, what are examples of bullying and harassment? And I put them here on this slide. Now, I've just put up a few examples, so it's a non-exhaustive list, but here we go. Verbal aggression or insults. Okay, so being verbally aggressive towards someone, insulting your co-worker. So example, you're so stupid. Why did you put this section here? That was a stupid thing to do. So that's an insult, right? Okay, rather than saying to someone like, oh, maybe that section, I don't think that section should go there, or a plan that you and your co-worker have discussed. It's not what you say, it's the way that you say it. Spreading malicious rumors, gossip and spreading malicious rumors. I can't begin to tell you in my practice how often this comes up. Employers call me looking for advice on this. Employees call me looking for advice on this when they're contemplating filing a bullying and harassment complaint under their employer's policy. So spreading malicious rumors and gossiping, my advice is just don't do it. Threats of violence. So threatening someone to cause harm is bullying and harassment behavior. Okay, so threatening to beat someone up, I mean, that's obviously a very glaring example. Hurting someone, threats of violence, a clear example of bullying and harassment. Personal attacks on someone, completely unnecessary, engaging in personal attacks. Calling someone derogatory names. I'll just use an example here. I'm Irish, I'm from Ireland. So if someone kept saying to me, oh, you're a little leprechaun. Now, I'm saying that just as an example. But again, that is bullying and harassment, okay? That's a derogatory term, okay? Harmful hazing or initiating practices, vandalizing personal belongings, and these are all examples of bullying and harassment. Another example that does come up in my practice, and I didn't put everything on these slides. Social media bullying has spiked in recent years. So Instagram, Facebook, bullying online, that's another form of bullying and harassing behavior, okay? So these are just some examples here, okay? Now, we have an understanding of what bullying and harassment is. So what is not bullying and harassment? Again, it comes up all the time, so that's why I'd like to cover it. It's not bullying and harassment when two co-workers or a worker and a supervisor or a worker and employer have a difference of opinion, okay? We've all got independent thought, we all have ideas, we're all smart people. And so expressing a difference of opinion is actually not bullying harassment. Having an uncomfortable conversation is not bullying and harassment. Sometimes you need to have a bullying or you need to have a uncomfortable conversation to clear the air, okay? Just to get things going again. Again, not bullying harassment. However, if you're expressing a difference of opinion with your coworker and employer, and let's say I've got someone sitting opposite me here and we're talking about it and we're having a difference of opinion on an issue, and then I stand up and I decide to like overarch and kind of like get into someone else's space and kind of dominate the conversation. We're now moving into behavior that's not simply expressing a difference of opinion. We've now gone that step further, okay, into, intimidating the other individual, okay? So always go back to the definition: intimidating, humiliating behavior, okay? Offering constructive feedback, guidance, or advice about work-related behavior is also not bullying and harassment, okay? So you could be in a performance review And maybe the employee needs some areas that need to be improved upon. So giving someone feedback, constructive feedback on how they can improve and all the areas that they're doing right, and then just moving into areas where they can improve in a very respectful, professional manner, also not bullying and harassment. Okay. Where an employer or a supervisor takes reasonable action to manage and direct their workers. So that's not bullying and harassment, because management and supervisors, they need to make decisions to either get their team working on a project or a task. Reasonable decisions, reasonable actions to manage workers, that would also not be considered bullying harassment. Okay. All right. So just again, a few examples just to get everyone thinking clearly what bullying harassment is and what it is not. Okay. Now, what are my duties regarding bullying and harassment in the workplace? Now, I put this slide here because I think someone asked me this a couple of days ago, and I said, you know what, I'll put it up here because it's important for everyone who signed up for this webinar today to understand that not only does WorkSafe set out the obligations and duties of workers, but also supervisors and employers all have duties and responsibilities regarding bullying and harassment in the workplace. Okay, so here's the question: what are my duties regarding bullying and harassment? And the answer is WorkSafe BC's occupational health and safety policies outline duties of employers, workers, and supervisors in preventing and addressing workplace bullying and harassment. So think about it like this. On a very simple level, we all have obligations. All of us do. We're all in the workforce. Okay, we're all in the employment. We're all in an employment relationship. So it's important that we all look out for each other and that we all share. It's a collective responsibility to ensure that bullying harassment is not taking place in the workplace. So let's get going with the workers' duties, okay? Okay, duty number 1, do not engage in bullying and harassment. Right off the bat, don't engage there, and then you go back to, well, what is bullying and harassment? Spreading malicious rumors, threatening people, hazing, and sabotaging their work. Okay, so don't do it. Workers' duty number 1, do not engage in bullying and harassment. Number 2, now you'll see this come up quite a bit throughout this webinar, reporting if bullying and harassment is observed or experienced. So remember I said about this collective responsibility, okay? So there is a duty on a worker, just like the employer and the supervisor, to report bullying and harassment if it's observed or experienced, okay? And we'll get into reporting procedures in a wee bit, but reporting is important, okay? And applying and complying with the employer's policies and procedures on bullying and harassment. So yes, it's important to understand what bullying and harassment is, but then there also has to be, well, I know what it is, so what do I do now? What are the procedures? Is there a policy that I can go to where clearly sets out the procedure for reporting bullying and harassment and the steps that are followed to prevent this from occurring? Or if my colleague feels that they're being bullied and harassed, where is the workplace pod? Where is the bullying and harassment policy? Is there a procedure in place? So that's very important, and we'll get into that in a wee bit. Okay, so that's the worker's duties. Now let's switch to the employer's duties. Okay, so same as a worker, employers should not engage in bullying and harassment conduct. Okay, number 1. Number 2, an employer, and this is all set out in WorkSafe's policies, must develop a policy statement on bullying and harassment. And just to pause there for a moment, whenever you have a spare few seconds, if you haven't already reviewed WorkSafe BC's website, It's extremely user-friendly and it has a section devoted to employees and employers. And there actually is a simple one-page policy statement that WCB has. You can tailor it to your needs. So for all the employers who've logged on today, or supervisors, there's actually a very simple one-page draft policy statement on bullying and harassment. So you can take that, tweak it to suit your own workplace, but developing a policy statement on bullying and harassment is a must for an employer, okay? And now we're getting into the prevention component. An employer must take steps to prevent or minimize bullying and harassment. Must take steps to prevent and minimize bullying and harassment in the workplace. Develop and implement. So it's great to develop and have a policy, but if you're not going to implement it, it's not going to be of much good. So implement procedures for reporting incidents and complaints. There must be a set procedure, steps for reporting incidents and complaints. Developing and implementing procedures. So you've got the reporting component, but now you have to develop and implement procedures for dealing with incidents or complaints. So you've got the reporting part, now you need to deal with it. Informing workers of the policy statement and steps to prevent bullying and harassment. So it's excellent to have a policy on bullying and harassment, or a respectful workplace policy. It's excellent to have a very clear procedure in place. That's all wonderful. But if your workers, if your employees don't know where it is, then they just don't know where it is. So what I would say is, and it's part of the advice that I give to employers, is to, as part of the onboarding process, it could be part of the manual or the welcoming package that has the key policies that the employer has in place, so that a new employee who's being onboarded can see the bullying and harassment or the respectful workplace policy in place, can read it, has been given the opportunity to ask questions about the policy, so that, and if they understand it, fantastic, they sign off and they date it, so that they have a clear right off the bat, they know that there is a policy there. And also, you know what, every year, no harm taking out that policy just to review it. For employers, put it on your, I don't know, your intranet, your internal web, web online, whatever program you have, so that your employees can see all your policies. And we'll get into this later on the training of policies, so that employees are very clear on, well, what's in the policy statement and what does it mean and what are the procedures, okay? All right, continuing on with the employer's duties, training. So you heard that I mentioned about training. Training workers and supervisors to recognize the potential for bullying and harassment, to respond, and to follow the procedures for reporting. So that's very key there. Training, recognizing the potential for bullying and harassment, responding and following procedures. And if your policies have been, if you feel they need a refresh, no harm. I'd also, maybe poor choice of words there, but certainly review your policies from time to time to make sure they're compliant with WorkSafe BC's policies, okay? So an annual review of the policy statement and your procedures. Can we do things better here? Now, I did not put up on the PowerPoint slide supervisors' duties. You'll recall that I mentioned a few moments ago, workers have duties, employers have duties, and so too do the supervisors. So in supervisors' duties are very similar. Do not bully and harass. Okay, so that's duty number one. And number two, supervisors, just make sure you're complying and applying the bullying and harassment the procedures in place. You're bullying harassment policy. So don't bully and harass, and don't engage in that behavior, and also make sure you are complying with the policy yourselves, and you're also you're applying it as well, the content. Okay, I hope I'm not going too fast here. All right, so I've talked quite a bit now about WorkSafe BC, the duties, the policies, and their website. Now I'm going to shift gears, and now let's look a little bit more on harassment and another piece of legislation. And this slide talks about the BC Human Rights Code. And if you have a few moments later on or over the weekend, I would recommend playing around, trying out the BC Human Rights Tribunal. The website is extremely user-friendly, and you can see the grounds, the prohibited grounds of discrimination in employment. I put up a few examples here of the grounds on this slide, but I would highly recommend that not only do you familiarise yourself with WorkSafe BC's website, but also the BC Human Rights Tribunal. It's incredibly user-friendly. Okay, so let's talk a little bit here about harassment. All Canadian jurisdictions have legislation prohibiting discrimination based on prescribed grounds, okay? And these prescribed grounds, I put up a few examples here, not all of them. So in BC, we have the BC Human Rights Code, and it prohibits discrimination in employment on the grounds of sex, sexual orientation, gender identity or expression, race, religion, physical disability, and mental disability. Okay. Now, sexual discrimination is a form of harassment. There's lots of cases on that, and I don't have time, unfortunately, to go into the jurisprudence of the BC Human Rights Tribunal, but I really just want you to familiarise yourself with harassment, the BC Human Rights Code, and like I said, not all the grounds are listed here. Other grounds include age discrimination, marital discrimination, criminal conviction. I don't think I put a political expression. So there are a number of grounds that are set out, and I'll give you the section. It's section 13 of the BC Human Rights Code. It talks about prohibiting discrimination in employment. So for those of you who would like to read legislation on the code, it's section 13 of the BC Human Rights Code. Now, a question that has come up, so again, I put it on the slide. Michelle, what happens if an employer fails to respond to a complaint of harassment? So employee A complains about employee B, they feel like they've been harassed, and they go and make a complaint to their employer supervisor. So what happens if the employer decides, oh, I just won't do anything about it? So here's the answer. The failure of an employer to respond to and properly investigate reports of sexual harassment or harassment based on other remunerated grounds in the code, grounds enumerated in the code, and remedy such conduct, if it is found to have occurred, may constitute a breach of the BC Human Rights Code, resulting in liability to the employer. So, when employers, if you receive a complaint of harassment, act on it, respond to it, do an investigation. Key things there: act, respond, do an investigation. Okay, and I know that's a bit wordy, so I'll give it just to sink in for a moment. If an employer fails to respond to a complaint of harassment, that failure to respond and not investigate reports of sexual harassment or other harassment, okay, it's important that you appreciate that it's other harassment, on other grounds enumerated in the code, and remedy such misconduct, if it is found to have occurred, may constitute a breach of the code, resulting in liability. Okay. Now, again, this comes up So I put it on the slide. Well, it's challenging. It's challenging for an employer to determine the veracity of a harassment complaint. And yes, I would agree, at times that it can be challenging. However, it is always worthwhile to take all complaints, best advice, take all complaints and allegations of harassment seriously and investigate absent good reason. Okay, and we'll talk about the legal obligation to conduct an investigation in a second. But any complaint of harassment, take it seriously and investigate. Is that right? Okay. Now we're shifting in now to part 2. So what are employers' obligations? And you've probably already got the impression that there are a number of obligations on an employer. So let's get into this. I love this section, I have to say. I call it my P&R section, all right? Always think like this: procedures and I must respond. P&R, I must have procedures and I must respond as an employer, okay? Employers must implement procedures for responding to incidents of bullying and harassment. So P&R, be thinking that all day. These procedures must be reasonable. They must be a reasonable response to the report of or incident and aim to fully address the incident. So what is the redress? How do we address this and ensure that bullying and harassment is prevented or minimized in the future? So procedures and responding to complaints, crucial, okay? All right. Have a policy. So I spoke about that a couple of moments ago about the importance of having a policy. What does the policy say? Where can we find it? Is it part of the onboarding process? Okay, policies can and should provide for different options for addressing harassment, depending on the seriousness and the complexity of the allegations. Okay, so different options. And that different option can be the opportunity for two employees, just for example, to invoke an informal process to see if they can work things out. Okay, maybe more of a facilitative process. All right, so different options. Then, if that's not working, shift then into, well, what does the more formal process look like? So that's important. So the policy should have, let's call it some wiggle room there, okay? And it all depends on the seriousness and complexity of the allegations. If it's a serious allegation of sexual harassment, possibly treat that differently. If it's two employees where, things got out of hand, but they can work in it and they can maybe get back to good rapport, a good working relationship, maybe an informal process. So it is important to have flexibility there because not one size fits all. And I put here on the slide, an employee may be provided with the option of addressing a complaint through an informal process prior to proceeding through a formal complaint process. And I see in practice that actually works out quite well. Again, depending on the set of facts. Okay, so again, still with the P&R section, implementing procedures for how the employer will deal with incidents or reports of workplace bullying harassment must include, and I put up a few examples here. I find it useful to think of in terms of the who, what, when, where, why. So when you're developing these procedures, think about how and when the investigations will be conducted. Okay, so that's the how and the when. What will be included in the investigation? What about the roles of certain players? Well, you need to think about the roles and responsibilities of employers, supervisors, workers, and others. So the others could be, and I put it in brackets here, the investigators, witnesses, or union representatives, okay? And you could be in a unionized workplace. What does the collective agreement say? is the shop steward working on this particular matter? Is it the VP? So it's important to think about the roles and responsibilities of each player, okay? And the follow-up to the investigation. And I put in brackets here, description of corrective actions, a time frame, okay? I do see in my practice where I could be helping a complainant or a respondent just on reviewing some policies. They don't actually set out any time frame. You know, in 30 days, this step will then be followed. We will endeavour to get back within 60 days. Just, I'm trying out examples here. The time frame is crucial because I find in practice it causes a lot of stress to the parties involved, both the complainant and the respondent. And I think that could be avoided if there's a time frame in place. When I mention here about corrective action, it could be, you know, if there is a finding, if there is an ultimate finding that, you know, for example, an employee, you know, has bullied and harassed their colleague, are they going to be suspended? Are they going to get a warning letter? Could it lead to termination? Okay, so these items that I put up here on this slide are quite crucial to what should go into, you know, the procedure. Okay, and the who, the what, the why, and the follow up. What happens next post investigation? Okay. A question that I get quite often, so I put it up here on the slide. Michelle, my office has a respectful workplace policy. Do we need to have a separate bullying and harassment program? And my answer to that is, well, if you have a standalone anti-bullying policy, okay, you can have a standalone. You can have a standalone anti-bullying policy, or incorporate workplace bullying and harassment into a broader respectful workplace program. I have worked with organizations where they had a number of policies in place. They had a general respectful workplace policy, and then they had their bullying and harassment policy, and they had like an ethics policy, and so forth and so forth. And it all depends on the size of the organization and the resources. I've also seen a very comprehensive, about 5 pages, that incorporates respectful workplace and also the bullying and harassment all tied in together, and then the procedure and the steps. Okay, and so for example, the concluding section of their policy would deal with you know, the time frame for submitting a complaint, what happens next, you know, the investigator who's going to go in and investigate this complaint. So you could have a one-stop shop comprehensive policy dealing with both what's involved in a respectful workplace and also bullying and harassment. So that question comes up quite a bit. Okay, and again, as I mentioned previously, reviewing your existing programs to ensure compliance with WorkSafe BC's occupational health and safety policies is very important. An organisation that I help, every year they have a review of all their policies, and they have training sessions to their employees, so that their employees, both the existing employees and new employees, are very familiar with their policy. Because again, sometimes the policy can be put in the drawer and never looked at again. So it's just helpful to have a refresh every year. Okay, now this is important, so I put it on the slide. An employer who responds quickly and effectively. Okay, so I underlined that not to be not unnice, but to highlight how important it is to respond to complaints or incidents of bullying and harassment quickly and effectively. Okay, to remedy an incident and prevent recurrence of harassment, because an employer who acts quickly and effectively will not be liable to the same extent as the employer who fails to take such steps. Okay, so bear that in mind. If you get a complaint, try and deal with it as quickly, respond quickly and effectively. And just to pause there for a moment, I'm not saying act in haste. I'm not saying rush off and rush to conclusions. I'm just saying deal with the complaint quickly and effectively. And again, having a comprehensive policy and procedures in place will help you in that regard, okay? Because your steps will be very clear as to the process and the time frame, okay? So that's important for employers and business owners who do receive complaints of bullying harassment. Deal with it, respond with it, act reasonably, and follow your own policy, which is important. Okay. I'll just give a few seconds there. Okay, we're in good time. All right. We're coming towards the end, which is good. We've got some time here for, I hope everyone is still with me. Okay, part 3, conducting an investigation. An employer has a legal obligation to investigate a complaint of harassment in the workplace. So employers are under a legal obligation to investigate a complaint of harassment in the workplace. Okay, now the employer might say, well, I conduct an investigation, like, okay, so where does that get me? Well, conducting an investigation can limit potential employer liability. Okay, because if you have a policy in place and it speaks to conducting an investigation within a reasonable time frame, and then that's not followed and your own policy is not complied with, fast forward to a case possibly before the BC Supreme Court, that's not going to look good. Okay, and it can result in quite a significant employer liability. A question that I get all the time, so I put it on the slides. Who should conduct the investigation? I'm asked that like at least once a week. Who should do it? Okay. The short answer is, not to be too legalese here, but it will depend. It will depend on the specific situation at hand, okay? And if it's a very serious, complex, lots of allegations, it's better in those sets of circumstances to consider hiring a third-party investigator. And we'll get into that in a moment, why that's so important, hiring a third-party investigator. But really, it will depend. It really will depend, okay, on who should conduct the investigation. So I put up a few bullet points here on this slide. Okay, so to help us decide as to who's going to conduct this investigation, you really need to think about the parties to this complaint, the particulars of the complaint. How complex is this? Are there multiple allegations here? Like, what exactly are we dealing with here? Okay. Because depending on the parties and the particulars, you may need to hire someone who has specific training on trauma, and you need to make sure that the investigator has the proper skill set and the skills to be able to interview witnesses, write a report, make findings, and so forth. So there's a number of items that you need to consider when deciding on who should conduct the investigation. Okay, the procedures prescribed by applicable policies or the collective agreement if we're dealing with a unionized workplace. And the resources available to the employer. It could be that the employer is able to deal with this investigation. It could be something that's relatively minor and that the employer or someone in HR will be able to do the investigation, okay? It all depends on the facts, okay? And the particular set of circumstances. Big picture, whoever the investigator may be, objectivity and impartiality crucial to the process. So it's important to be objective and impartial, neutral when you're doing an investigation. And I'll talk about a case very quickly towards the end of my presentation, because that's key. being objective, going into the investigation with an open mind, and being impartial is crucial to the success of the process. Understanding of how to go through the steps of the investigation is also essential. This includes, as I mentioned, interviewing parties and witnesses, asking the appropriate questions to gather the facts. So if an organization feels that maybe we don't have the skill set, or we don't have the experience to conduct an impartial, objective investigation and a fair investigation to both parties, maybe that's the time then to hire an outside investigator, an external investigator. A flawed investigation may expose employers to legal liability, including claims of wrongful dismissal. Because if the investigation is conducted in an unfair manner that results in someone losing their job or being terminated with cause, that could lead to a claim of including wrongful dismissal. And that is what happened in the case of Vernon, the BC, British Columbia Ministry of Housing and Social Development Liquor Distribution Branch. It's a 2012 decision. It was before the BC Supreme Court. So it's been around for quite a while, but it's still a very important case for employers to pay attention to, not getting the appropriate person in place to conduct a fair investigation and resulted in significant liability to the employer. So just very quickly before I open up the floor to folks who want to ask me questions, this case of Vernon, I'll just call this case Vernon, it was a wrongful dismissal action. And the plaintiff, Mrs. Vernon, she was terminated for cause after the employer determined that another employee's complaints about the plaintiff, Miss Vernon, were founded. Now, this lady, Miss Vernon, the plaintiff, she was a 30-year employee and a senior store manager, and she was accused of bullying, harassing, and intimidating her subordinates. And one of the things that went wrong was the investigation, primarily the investigation. The court held that the employer's investigation into the complaint was flawed, biased, and unfair. Okay, so these are findings. You can pull this case, you can go onto Canley and Google Vernon, and this case will come up. All right. So very quickly on the facts here. So this lady, the plaintiff, Miss Vernon, had worked with the Labour Relations Advisor regarding the complainant. So I think there were issues between the two ladies. So this Labour Relations Advisor was very aware of the dynamics, let's say, between the plaintiff and the lady who made the complaint. Okay, and the court found that the Labour Relations Advisor should not have been the one to conduct this investigation. And what I did here, this decision is actually 85 pages, but don't worry, I'm not going to read 85 pages. I do just want to read one or two paragraphs so that you can appreciate what went wrong here when the employer decided to hire ultimately the wrong person to conduct the investigation, which was ultimately this labor advisor individual. Okay, so here's what the judge had to say. I will start it from here. Given Miss Vanderboom's role, so Miss Vanderboom is the Labour relationship advisor, role as Miss Vernon's Labour Relations Advisor, and her specific role in advising Miss Vernon about the complainant, she should not have been put in charge of the investigation. So this is what the judge had to say. As a result of her interview of the complainant, Miss Vanderboom appears to have been convinced of Miss Vernon's wrongdoing. Following that interview, she put together a list of employees to interview, including Miss Meyer, who she knew would likely have negative things to say about Miss Vernon. The interview of Miss Vernon was contrary to its intended purpose and unfair in the extreme. So this is what the judge had to say. It was unfair in the extreme. Miss Vernon thought she was meeting with her labour relations advisor and area manager to discuss in an informal setting a complaint that had been made against her. Instead, she was the subject of an intense interrogation. The person who she had relied on as her labour relations advisor was now her interrogator. Miss Vernon was upset at the meeting, and she had good reason to be. So obviously not, the judge didn't like what happened here to Miss Vernon, and the decision talks quite a bit about the unfair investigation. And ultimately what happened here was that the judge, the court, awarded Miss Vernon, the plaintiff, 35,000 damages and aggravated 35,000 in aggravated damages, 50,000 in punitive damages, and Miss Vernon, she was awarded 18 months severance pay. The big picture, big message, key takeaway from this case is the employer's reliance upon a flawed investigation resulted in significant liability, as well as the loss of a valuable and devoted manager. Because Miss Vernon, like as I said, had been with the company for 30 years. She had won awards. She had excellent performance reviews. So it's sad all round, really. And this may well have been avoided if the investigation had been conducted by an experienced and impartial investigator who did not have previous involvement in the dispute between the plaintiff and the complainant employee. So that brings me just a wee bit over, Sadie, to our part 4 question and answer session. I'm quite happy to stick around a little bit after 1. So I'm all set for questions. I hope you enjoyed that.
Thank you so much. That is, yeah, it was so interesting and I think really helpful for so many people, both from the workers and the employer's side. So, yeah, feel free to turn on your cameras if you would like to pose a question. We do have one already in the chat, which is fantastic. So feel free to either throw your questions in the chat or raise your hand, and I'll read out the questions for Michelle. So we
Okay.
have one from Kathy, who is asking, coming from a nonprofit, we work with a lot of volunteers. Should volunteers be covered under a company's bullying and harassment policy? And
Yes,
also, what happens if a volunteer participates in bullying staff or vice versa?
yes, it should cover volunteers for sure. Yeah, and the policy in place should cover all members of the team. So I hope that I'm trying to be yeah. So yes. If your volunteers are working on your premises, part of the team, and I don't know, the question was like a not-for-profit organization, but it's still part of the team. Working with employees, working with other team members, and your respectful workplace policy. Again, it could include also bullying, harassment, and they should be following that.
Fantastic. Thanks so much. Lise, I see that you've got your camera on. Did you have a question that you wanted to pose?
Hi, Lise.
I actually was following up with that volunteer component. So I belong to an organization that is completely volunteer driven. I'm on the board, and within the board, we could potentially be wanting to deal with similar situations. So I just assume that you would give us the same advice. Yeah.
Absolutely, yeah,
Yeah.
100%.
No, that's great.
Yeah, anytime.
Great, thank you so much. And we do have another question in the chat here from Emily. I was wondering, what would an employee do if an HR manager engages in bullying?
Excellent question. Again, it goes back to the procedure, the policy. If you feel it's HR, and then there should be an alternative route that you go to the owner or you go to the president, and that should be set out in the policy steps. Because you're right. It could be employee, it could be employee and supervisor, it could be employee and HR. Then where does that individual go? So it could be the owner of the company, it could be the president, it could be someone else within the organization. Because that's tricky. I actually come up with that. That happens a few times.
Yeah, I imagine
I
it
see
must get
that in
so
practice.
complicated in some of those cases when there's already a power imbalance, and then
Yeah.
who do you go to in that case? Yeah. Okay, does anyone else have any more questions?
I'm sorry, Sadie, I've actually seen like excellent protocols in place by business owners where they actually have just one employer that I deal with. They have like a bulletin board, and they actually set out like their contact information, or their could be their right hand person, their VP or whatever, that says, if you feel you can't talk to, and we'll just use the example of HR, you can contact me anytime. So again, it could be a very simple remedy, uncomplicated. So if you feel that this person, then who do I go to deal with it? What's the procedure?
Yeah, thank you so much.
Yeah, anytime. And what I'll do is, I'm so happy to listen to questions. I'm just going to, I forgot to go to the resources page. I know I did mention about WorkSafe BC and the tribunal, but there is lots of really good information and resources on WorkSafe BC, WorkSafe BC's website. And they also have a toolkit for employers and supervisors. Like it's really excellent. I can't talk enough about it, and also for the BC Human Rights Tribunal as well. So here's some resources, and I know, Sadie, you're going to provide these links and the slides to everyone. And what I'll do here is I'll just leave my contact information up here in case anyone wants to call or email me this week if they run out of time during their lunchtime.
Amazing. Yes, and exactly as Michelle said, we've got the recording that we'll be sending out to all of our registrants, as well as the slides. Yeah, this was so wonderful. We have another comment in the chat. Michelle, thanks so much for an informative presentation. The review of Vernon versus the employer was very interesting. Thanks for decanting the takeaways. Yeah, and I agree. There's so many amazing nuggets of helpful information for everybody in here. And yeah, thank you all so much for attending. Happy Pink Shirt Day. If you haven't got your pink shirt on, it's not too late. Yeah, and any other last things, Michelle?
Anytime.
Okay, wonderful. Thanks so much, everyone, and have a fantastic day.
Bye, Sadie. Bye, everyone.
Bye.